Go, record. All right. I haven't always been an estate planning attorney. I used to do a different type of law. So I did Social Security, disability. Basically, I came into people's lives after this terrible train wreck had happened. Either they were severely injured or had some sort of debilitating illness, and they couldn't work anymore. So I was coming in and trying to pick up the pieces for them. Right, and it was one of these things that people thought would never happen to them, and a lot of times there was no plan in place for what would happen or what they would do if things like that happen. And I'm convinced nothing bad like that is ever going to happen to me either. But at one point, I was just living my dream life, just being an attorney, helping people with those claims they had. And I had started surfing, so I was in my 30s doing my bucket list type thing, and went out. I don't know if you've ever been to Westport out there. Started surfing out there with a friend, and one day my friend said, "Hey, these giant waves are coming in now. They're 10 feet high. Let's go. It's a great idea." And so of course I'm like, yeah, why not? I've been doing this for 8 weeks. Why not? And so we get out in the water, and basically there's a rock jetty out there in Westport, and there'll be a current that basically pulls you out into the ocean, and that's how you get out beyond the waves. So I'm in that spot, and I'm paddling out, trying to make it for all the next wave comes in, and come really close. Didn't quite make it. The wave picked me up and tossed me right into that rock jetty. And I'm suddenly panicking there and turning around and trying to paddle back to the beach, totally forgetting about that current that's taking me out. So current's pulling me out to sea, waves are coming in sideways and slamming me into those rocks. And it was in that period of time that I realized maybe something terrible can happen to me. And here I was thinking that I always planned for so many things, and felt I was always so prepared, and suddenly realized that I wasn't. And I was out surfing that day. I hadn't told my wife where I was going. We were recently married. We were putting all of our money into an account that just had my name on it. I was wearing a full rubber suit with no identification or anything, and it's if I end up in the hospital, who's going to know who I am? How's she going to find me? There's all these things I was thinking about afterwards that were terrifying. I mean, I felt like almost a horrible failure for putting myself in that situation and almost leaving this huge mess for my wife to clean up. So I used to forget to tell people. There was a little window of time where the waves died out a little bit, and I was able to climb up some of those rocks and basically passed out on top of the jetty there for an hour or so recovering. And I realized then I needed to make a plan for myself to be better prepared for things like that. So that was the start of how I switched to becoming an estate planning attorney, how I moved from coming in after something terrible had happened and then planning ahead of time for people to avoid that type of mess, right? And one of the first things my clients think about, first time people think about estate planning, is when they have kids. I think that's a lot of people either know or have heard that they should name guardians for their children. And it's important. And does anyone know why it might be important to name guardians for your children? Anyone want to throw out a little participation here?
Otherwise it goes to the court.
Yes. Otherwise it goes to courts. Basically, if you don't choose a guardian for your minor children, a judge is going to pick for you. So a judge who doesn't know you, who doesn't know what's important to you, he or she will decide what they think is in the best interest for your kids, and it might not be the same person you would pick. My sister has a young child, and she does not want me to be the guardian if something happened. She has her best friend. That would be her pick, and that is her pick because I did her documents for her. But if she hadn't done any planning, and a judge was looking at it, is the judge going to pick, closest relative, has a job, seems like a normal person, I hope, or her best friend, right? It's more than likely would go to a family, and that's not what she would want. It might be what a lot of people would want, but not her. We have some friends here in town, and they just recently asked us to be their first pick for guardian. And again, if they don't put it down in writing, there's no way we're getting picked. I mean, we wouldn't really. I don't know. I mean, we wouldn't really have a hat to throw in the ring. The judge would be picking one of their family members that lives here, but that would be one of their last choices, right? For all these different reasons. And I think we could talk about some of those reasons here tonight. If not, I also have some resources that you can use online that can help you choose those guardians if you're having a tough time picking out a list. Has anyone thought about it before and know who you would pick for a guardian? See some hands back there.
It's changed for my family.
Yeah.
Because 5 years ago, people would have been ready, but 5 years later, things change.
Yeah.
So I would have, it's different now than I did 5 years ago.
Yeah. And that will hit on that on number 7 on the sheet, right? Because it's something that changes over time. When people come back to us to update estate planning documents, usually the one document they're changing is the guardian nominations. Right? Okay.
Seems like a difficult conversation. I don't know that I want you to be my guardian anymore.
So, we talk with people about making that list, essentially trying to form some objective standards on how you come to your decision, partly as a way to say, these are all the things that we want in a guardian, and I don't know, this is why you're not them. I mean, so an important thing to keep in mind is that just because you don't name a guardian doesn't mean that the person wouldn't be involved in your child's life if you weren't around anymore, right? So the documents that name guardians can just be one part of your plan, right? You can also put together wishes of, this is what's important to me. I want my child to do this, to do that. I think these people should be involved in their lives. They should, in the summers, try to go visit these family members. So it's not just the one legal document. There could be more to it. So you make sure that what you would wish for your child now can continue to happen if for some reason you are not here. And that's really the only way to preserve that voice of yours is to do that in writing, because once you're gone, you can't speak for yourself anymore. I don't see too many glum faces yet. That's good. So I wanted to go through this list here. It's a pretty good outline of some important things to consider, and we can just go and answer some questions as we go, if that's all right. So a lot of these things, 6 of them we call some of the common mistakes that people make when choosing guardians. So let's look at number 1. If you're naming a couple to act as guardians, make sure you decide what happens if the couple breaks up or one of them dies with you in a fiery crash or something. Actually, one of my first clients, I was talking to them, and it turned out they're best friends, and their first pick for guardians, they would go flying on the weekends. So the 4 parents, they'd go out in these little prop plane and go flying around. And it's it's really important that you have some backups or deciding what happens if something happens to one parent and not the other.
Just pick one and then have husband be backup parent or backup guard?
Yeah, so what I recommend is to think about the couple. If you're really okay with both of them being guardian, you could designate both of them and say whether they survive or not. If they're split up, then choose this person instead, just the one. Or if it's really just one person in the couple that you want, just put that person down. They become the legal guardian, and then they can fill out paperwork so their partner can pick the child up from school or do other things like that. But the one person would be the legal decision maker. I see it a lot when it's like, a sibling and their spouse, right? It's like, do you really want the spouse if something happens to your sibling? And most of the time I'll just put my sibling down. So, and so the reason it's important to do that is just the goal of making these documents and this plan is to make things as easy as possible and not have people in court fighting over things, children, money, whatever. So number 2 is naming more than one potential guardian. I get asked a lot if the people you name in these documents will be required to serve as guardian, and they cannot be forced. A judge can't make them just because you put it down. They are able to pass on it. So if they don't want to be guardian at the time, nobody's going to make them. So it's important to have backup choices. So typically you have your first choice and then 2 to 3 alternates. And not just because, they might not choose, there might be whatever reason why they can't do it. Their circumstances might change, they might have moved, might be too far away, don't want to come back, you don't want your child to go there. So just choose some alternates and have some backups, basically. All right. Number 3 is avoid taking financial resources into consideration. So when we walk through the process of choosing like your top 3 picks for guardians, we have people, one, make a list of who they would be happy with, just kind of, gut reaction of who would be a good guardian, friends, family members, old college roommates, whatever it may be. And then we have them list what's really important to them as a parent, like what values, priorities, that sort of thing. And then we match the 2 lists up to see who best fits what's important to you. One of the most common things I see people debate is who has the financial resources to take on the children. And I think it's important to not consider that, because that's something that you could plan for ahead of time, right? If not by savings, then by life insurance, some other means to provide that support to the guardian you pick, who will have those values and priorities that you think are important versus just having enough cash to, pay their, food and shelter, that sort of thing. So number 4. Number 4 is consider creating a living trust to avoid a court process called probate. So when you are incapacitated or die, if you own real estate or more than $100,000 of assets, your stuff goes through a court process called probate. And probate is what I like to call a lawsuit. You file against yourself with your own money for the benefit of your creditors. So it's the process of passing title from your name to the people who get your stuff, either in your will or whatever the default rules are if you don't have a will. And, it's fine. That process will work, but it takes time. Usually it takes about 6 to 9 months to get through. It's a public process, so everyone can see what your child will be inheriting. And so that can cause unnecessary delays and expenses. So there's a ways to avoid that process and make sure that the guardians are able to get the money to take care of your kids in a faster, easier process. Yeah.
In regards to a living trust, can that include your life insurance, your retirement funds, so an IRA, and all that can be put into a living trust?
Yeah. So that's one of the biggest mistakes I see people making, is that they name their minor children as beneficiaries on retirement accounts, insurance, investment accounts, anything like that. And children can't inherit property. So what happens is that instead gets placed back into your estate and goes through that probate process. So if somebody has set up a trust, you can name the trust as a beneficiary. That's one of the most common ways to avoid that probate mess. There's other things you could do. I mean, you can set up custodian accounts with your with your brokerage account, retirement accounts, that sort of thing. There's other ways to do it, but it's typically too much to talk about in a short presentation like this. But I guess number one thing I would say, if you have your children named somewhere as a beneficiary, then that is a red flag for a big mess. And on that topic, the solution is not to just name the guardians as the beneficiaries. It seems like a logical solution to it. And as much as you trust the guardians, and I'm sure they would use the money properly for your children, it becomes their money to lose. So if they were to get a divorce, half of that money could be gone, and they could lose it in a lawsuit, for a car accident, something like that. It's not going to be your child's money. It's the guardian's money to lose. Any questions there before we go? Yeah.
Another question. So once you've reached a certain age where the likelihood of you dying naturally, then you dissolve the living trust?
Yeah, I mean, I think I see that quite a bit, is that people have it when they have a minor child, and then they might, get rid of it over time, and then maybe circle back to it if they come back to the kind of end of life planning again. I mean, a lot of people just want to avoid that probate process in general, even without minor children. So it just depends on the people. If you get used to, handling it, then it might just hang around forever, I guess.
Is there a regular ongoing cost for a living trust?
No. No, there's not, because that was the hardest thing for me as a law student in trusts and estates, was just understanding why something is then in a trust, because your name is still there, you just put trustee after it on everything. It didn't make sense to me. But once you get it set up and going, then it just keeps on going, and there's no annual cost or anything.
Do you have to take into account state taxes and stuff? Meaning, if your state's worth more than a certain amount, then you have to think about that for the beneficiary too. Minors.
Yeah, so in Washington State, there's an estate tax. Right now, it's hovering around $2.1 million per person. So that first $2.1 million, there's no tax, and then above that amount, there's an amount between 10 and 19%. The federal estate tax now is up to $11 million per person. So most people don't have to worry about it. But usually inside of a trust, living trust, there's some sort of tax provisions just to reduce income tax, capital gains tax, estate tax. Yeah.
Do you hold real estate in the living trust as opposed to husband and wife?
Yes. Yeah, because Real estate is typically the one asset that will pull you into probate. So it's held inside of the trust instead of their personal name, and it's still pretty much the same as them owning it personally. Like, they still get mortgage interest deduction, capital gains exemption when they sell it, that sort of thing.
You just have to go change the title with whatever.
Yeah.
And it doesn't like mess up your mortgage company or anything.
No, mortgage company can't stop you from doing it. It's pretty common, yeah.
Is there an order of precedence? And like, let's just say we're talking about life insurance. You can name a beneficiary, but let's say something happened to me and not her. Is it like an if-then? If it's just me, then she's the beneficiary, but if it's both of us, it's the trust?
Yeah, so usually people have a secondary beneficiary or contingent beneficiary, primary beneficiary, secondary beneficiary, something like that. Yeah. Yeah, typically I tell people, if you have named the children somewhere as the secondary one, just change that to the trust, if you have that set up. Yeah, because a lot of people will keep it in the first one as a spouse, just because there might be some tax or other benefits keeping it in the spouse's name. Okay, we can come back to this one. This is usually the big hole that we go down at the end of them. So, number 5 is excluding anyone who might challenge your guardian decisions, or who you know you'd never want to take care of your kids. When my wife presents with me, we get to talk about her crazy aunt. So anyone, our courts are open. They have open door policies. If somebody wants to come challenge your decisions, they are free to do so. So if you have, especially if you've named like a friend or non-family member, you might have someone in your family who says, hey, wait a second, like, I should be the guardian. I'm the best pick. So there's nothing that's going to stop them from being able to go in there and say that. So I recommend to people, if you have someone like that in your family, or there's someone who you wouldn't want to take care of your children, you can write a letter. And it doesn't have to be a letter you give to the person or show to them, right? Think of it like a confidential letter addressed to a judge who might be considering this issue, all right? It's kind of like a open if necessary.
Does it stay confidential once it's like, let's say I die and I don't want my crazy sister to have my kid? Not that I have a crazy sister, but hypothetically, would she ever see that and like,
well,
be part of the public file?
Yeah, so that's maybe part of the leverage of, hey, don't challenge my decision, because this letter is going to be opened and it's going to become a public record through the court process. The other alternative, if you don't want to write that about a specific person, is perhaps writing a letter or some more documentation about why you chose the guardian that you chose. We talked about that list of values and priorities. You can go through why the people you picked, match up with those. They're aligned with that, and why, other people are not as aligned with it. Again, it's preserving your voice for if you're not here anymore to speak for yourself. And so a lot of these documents I'm talking about, they are not mentioned on here, but there's a website. It's not a website we built, it's another attorney, but we have access to it. And it's actually, if you have a pen or want to type it down, it's layroots.kidsprotectionplan.com. That's Layroots, LAYROOTS kidsprotectionplan.com, and you go through the process on that website. You go through the process of choosing those potential guardians. Like I was saying, coming up with a list, 5 or 6 people who you would be happy with to serve as guardian, and then the list of what's important to you as a parent, matching the list up, and then you enter more information like who they are and contact information, and it will spit out the long-term guardian, like permanent guardian forms, temporary guardian forms, letters to exclude crazy aunts, a whole bunch of stuff. So a very like comprehensive kids protection plan, I guess that's what it's called.
Is Washington specific, or if you have to like say like I live in Washington, you need so many signatures or whatever?
Yeah, so it's built to be compliant, and I think it's every state but like Louisiana. So it'll work here. Basically what you do is the documents come out and you have two people witness you signing the documents. So two people who you didn't nominate on the form. So get some friends over and have them witness you sign it, and then they'll each sign it. And then make copies and then share them with people. And yeah. All right. Where are we at? 6? Make arrangements for the short term if you're in an accident. So I'm always sure to ask people where their guardians live. So if you're picking guardians who live elsewhere, or say more than 30 minutes away from you, it's important to consider what would happen in the short term, like while the permanent guardians are coming to grab your kids. So say you're coming home, there's a bad accident over by Canlis, like today. Maybe you were in that accident, and the first responders come, and they're looking in your car, and they see evidence that you have a young child. So once they have a hunch that you have a young child, they have a duty to make sure that the child is with somebody who is legally authorized to be with them. So they will go track down the kids and see who they're with. My aunt used to work here in Seattle as a nanny. She had the cell phone number of the parents and maybe like the doctor's phone number. But if those police came to her and she had the children, she had no authorization to keep the kids. She's not a legally authorized person if it's not in writing. You have to be a blood relative to be able to keep the kids and without having it in writing. So it's important to choose not only the permanent guardians but also the temporary guardians. Otherwise, the children could be put into temporary foster care, either at somebody's home or sitting at a police station overnight or something like that. So not the ideal situation, if they're getting the news that you're in the hospital, something like that. So I recommend people choose a list, again, 4, 5, 6 people who the children already know, like, and trust, who can be with them until those guardians arrive. If the permanent guardians have more than 30 minutes to get to them. That all make sense? Yeah? Does anyone have an idea of guardians who lives in another state or another country? Yeah? Yeah, so that'd be important to choose some friends, neighbors, someone from a group here. Yeah. And again, on that website, they'll have those temporary guardian forms as well. So number 7 is naming your guardians in a separate freestanding document. A lot of people just do it in their will, and that's fine. It'll work. But it's really easy to have a separate document just addressing the guardianship. That way you don't have to share your will with the guardians, the full document. It's really easy to just change. Like if you go and make these forms, you'll see it's just, you sign, your friends witness you signing it. If you want to change it, just tear it up and make a new one. It's a lot easier to do that than having to go through and make an entirely new will or update your will, that sort of thing. So consider doing those. And like I said earlier, it's the document I see changed most often. So it's convenient. All right, so I got through those really fast. I feel like there was a question back there.
We were talking about temporary guardians.
Yeah.
Like, say if the nanny had them, but she didn't have temporary guardianship, and those police officers came to the door, and nobody knew who the temporary guardians were except the people in the accident and the temporary guardians.
Yeah.
How do they go about finding who the temporary guardians are?
So on that website, there's a place to make instructions for babysitters. So instead of just leaving them your cell phone number and the doctor's phone number, it's detailed instructions of, if somebody comes in that scenario, here's a list of people. Just start calling down there. Let them know that their services are needed and they need to get there as soon as possible. At the same time, those temporary guardians have their instruction sheet that says if they get that call, grab the documents that they need to go meet them and have the proof to show the police. So it's just a matter of laying out those instructions. Yeah. If it's an emergency, call 911. If it's not that type of emergency, call these guardians first before you call the police to come.
And then typically the authorizations, how legally heavy do they have to be? Do they have to be notarized and like real documents, or do they write a letter and sign it with witness? Like how much effort is that little piece?
So they can be either notarized or witnessed. Witnessed by two people is sufficient here in Washington. If those documents end up in court, the judge might want to talk to the witnesses to make sure they witnessed it. But otherwise, witnessing is typically the easiest thing, unless drop by the bank and have it notarized, something like that. But both will do. Yeah.
If you have a will and does the will just reference a second freestanding document so that you can change that as you will, and then you just staple it to your will and then unstaple and restaple? You're saying you change just that part?
Yeah. So typically I'll say, I might put in there, we've named guardians elsewhere. Or if we're putting it in the will, we'll say it's also here and, go by that one. Yeah. Yeah, and then, keep them in a safe place. I keep all my documents in the back of a closet somewhere. I let people know where they're at. I mean, I also have them online, and I also have digital copies with people, but the originals I keep at home. I don't put them in a safety deposit box because it's hard to get one these days, and if I'm the only one with access to them, it can make getting the documents tough, and a lot of people will do that where there's no other authorized person to have access to the box, and then they end up in court talking to a judge to say, oh, well, we need access to this box because we think it has these documents in it. So, but yeah, I typically recommend just keeping it somewhere safe, maybe a fireproof safe or bag. That'll buy you some time if the place burns down. Make copies, share those copies with the people who you've named in the plan. We also have an online storage service that's, I'm blanking on the name of it, but it's basically a place to get organized online. It's called Everplans, actually, everplans.com. And you can store not only your legal documents, but other documents that give guidance to guardians and other people that you've picked for part of your plan. You can share those documents with them. You can give them access either now or only after you die. you have all these different options. There's like goodbye letters, that sort of thing. Whatever you want to do just to get organized and use as much of it as you want. Everplans, if you just sign up on your own, I think it's around like $80 a year, but we can give people, like we pay for a professional account. I can send you an invite and that'll just waives the cost of it. And you'll just see my face like around on the thing, but otherwise it's the same. But yeah, I'm happy to, if you email me, I think last time we did like a follow-up email, and I can include it in that.
I can send something somewhere out that went out to your one book.
Okay.
You end up in the same predicament as a safety deposit box. Do you put it in a safe? Something happened to both of you. Like, are you going to open the safe?
Yeah.
What's that?
You can bash open a safe.
Oh, I'm going to say goodbye, I guess.
Yeah, I mean, yeah, you kind of got to go through step by step of what would happen, and if somebody needed them. That's why I leave them in the closet. I figure if the boat burns down, it's going to sink. So even if it's in a safe, it's going to be underwater. So I just leave them out there. And I mean, most of these documents are good as copies as well. So even without the original, a digital copy will get you somewhere. Yeah. But yeah, I typically want people to just have access to them as easy as possible.
How much does it cost, like ballpark, obviously everybody has different finances, to get like a living will done? Like how much does that run? Like,
So there's a whole range, of course. I mean, anywhere from free, there's lots of online resources. There's one now I tried where it's like a robot, it's like a chat bot talking to you, and it's like asking you questions, and it spits out a document afterwards.
dangerous.
So
Kids likely could have.
the risk of those is that if you did something wrong, by the time people figure it out, it's going to be too late to fix it. I saw somebody who did something like that, and it wasn't with a chatbot because they made it like 15 years ago. And I looked at it, and the first thing I noticed was she didn't sign it. Like everybody else signed it, the witnesses, like things got notarized somehow, and they never signed the document. I was like, okay, so you've never this was never good. So it's definitely, can be a thing of you get what you pay for. I think range of like trust planning that I see in town is somewhere between $3,000 and $5,000. A lot of times there's a range because you can do additional planning within the trust. It's not just, give my stuff to this person. There could be tax things built into it. There could be other endless options of things you could do. So a lot of time that's the range. I tell people if you're planning to avoid probate, it's typically more of an investment up front, and it can save money on the back end, by avoiding going through probate. A lot of the cheap estate plans that attorneys do in town, they're actually more of a probate attorney. So they do out all these wills. They just say, oh, a will. All you need is a will. Everybody gets a will. And then the families come back after the person dies, and then they make, $5,000 to $10,000 doing the probate process. So, a whole range. I will say the important thing, if you do hire an attorney to do the work, is to look for someone with flat rates, fixed fees, right? You don't want to have to be watching the clock like a taxi cab. Because then the incentive is for them to make it, more work, have it last longer. Every time you call them with a quick question like, hey, what do I tell the bank? Like, how do I title it to be in the trust? You're going to get an $80 bill a couple of weeks later. So typically, most attorneys will do flat rate packages that includes all the important documents you need. May include some some online stuff and follow up every few years. Yeah. Any other burning questions? I mentioned that friends asked us to be guardians recently, and somebody in the last presentation had a good question, was how do you ask people to be guardians, especially if they already have children of their own. And this was the same problem and struggle that our friends had. They didn't, they'd been hinting at it for a while, and then when they finally asked, it's like, maybe just temporary guardians, whatever. Watch them for a couple days, and finally, worked up the nerve to say, no, we want you to be like the, permanent guardian. So the advice was to, when you ask them, well, first of all, if you're considering them, it's very likely that they love you and your kids and will be happy that you have thought about them for this job, but tell them about your plan. I mean, was my question was, okay, what's going to happen? Financially, what else is happening? So our friends were able to say, yeah, our parents have both set aside some money already. We have life insurance. Everything is set up so that things will be as easy as possible for you. You'll have money to continue paying for school or food, whatever it may be. And that makes it a lot easier to make that decision, right? And take that worry out of how am I gonna, have my family suddenly grow. And in your planning documents, it's not just that these people get the kids. You can also say, make sure that whoever's handling the money, make sure that the guardians can be comfortable in accommodating my kids. So if that means having to get a bigger car, or bigger van, maybe adding an addition to the house, that sort of thing. You can address those issues on the financial planning side of things.
Is that something you could kind of roll into the trust for managing it?
Yeah, basically you're saying this, this is what's important to me. Make sure the guardians, it's not just, paying the bills for the kids, but it's also supporting the guardians to be able to look after the kids. And whatever else is important to you, it's important that, they go to college or they have the ability to travel or go visit these relatives on the East Coast or wherever.
Are state lawyers going to have the expertise to help with that, or do you need to involve an accountant in that discussion?
I guess it depends on how much money you were talking about. I know when, with larger estates, it could, the CPAs and accountants or tax lawyers come in to figure out the best way to move things around to reduce taxes. But typically it's within your estate plan. Like if you're doing the trust, it's not just give it to them and, manage it until they're 25 or 30, but also what you think is important. And you can just do that in we call a letter of wishes. And it's kind of like an instruction manual for the person managing the assets for how to make distributions from your estate. Anybody? But so that's important if you're working with someone to make sure that they are asking those questions and figuring out what all is important. Our process, and it's not just to talk me up, but other attorneys do just fine as well. We have once we get through creating documents, then we go through documenting what is important to you, what would be important to you, for the person managing the assets to know, what's important for the guardian. Kind of like, you're making these different instruction manuals for the guardians and for the person managing the assets. It might be the same as the guardian, might be a separate person, but you can leave all your wishes for people to follow. Is that a hand? Yeah.
Does that work, or what would be your recommendation for people managing the assets versus the guardian? Like, I'm choosing the guardian who I trust the most, and so.
That's a good question. So the question is whether you choose the person to manage the assets and the person to look after the kids, whether they serve in the same roles or if you have separate people. And I let people know you can choose different people, right? Let the guardians focus on being the best guardian and not having to worry about managing the finances and keeping track of the spending and spreadsheets, that sort of thing. So it's pretty common that I have people choose the most organized, trusted person they know to manage the finances, and then the guardians to just focus on being the best guardian and kind of divide those duties up. And it's, in a way, also a checks and balance as well. So
set up where your distribution is different depending, like, from the first person you pick, and if they're not available, the second one, like, someone may have more means than another one. That makes sense. Where you may not want to have an expedition.
Right. Yeah, and they're trying to maybe leave more for the kid in adulthood. Yeah. That's true. Yeah. Go ahead.
I'm thinking about challenges associated with having multiple children. You have larger families, 2, 3, 4, 5 kids. How do you kind of cover that, especially if you're thinking about it relatively? You may not be willing to take, 3 or 4 children, maybe 1 or 2 or something. How do you?
Yeah. How do you? I guess again, it's part of the conversation of how they would handle that. If they would be able to accommodate that, and what type of plan you have to provide resources for them to do that. Children also get a say in it. Once they get older, it's either 12 or 13, they get to weigh in on who they go with. Yeah.
When you go in and meet with a lawyer, like with your initial consultation, looking at the flat fee, what does the go to ask for? Is it like, I want a living will and a regular will and this guardian thing? Like, what's normally like what's in the package that you're asking for?
Well, so for one, if somebody doesn't have a lot of assets or they don't think they would go through that probate process, setting up like that kids protection plan, that might be all of what they need right now. So for that's easy to take care of. Everybody also has a default estate plan. If you have kids, all your stuff goes to your kids. If you're married kids, it kind of goes to spouse and to the kids. So you don't really need a custom estate plan for that. Usually when I talk to people, it's focusing on how easy and fast they want things to happen. So basically, are we going to plan to avoid that probate process? If we are, how are we going to do that? So we typically have like just a basic documents package of not just will, but like who will speak for you if you're incapacitated, who will make healthcare decisions, legal decisions, that sort of thing. And then if we're avoiding probate, it's the group of documents that almost everyone would need, and then you could talk more about other considerations, like if you need to do the tax planning, or if you want to have inheritance protected for the child's lifetime, So typically there's like a standard set of things everybody needs, and then talk about what other things you might need to add on or that you could take away so that you can reach the goals that you have for your plan. So people are getting restless. How are we doing? 7 o'clock. Cool. All right. What else? Anything else? Trying to think of some other nuggets here.
If you and your spouse pass and you hand your kids off to the guardian that you chose and everything works well, years go by, they pass. Does your second choice is it still in play, or what happens?
Yeah. So the question is, so parents die, your guardian takes over, and then the guardian dies a few years later. So that's a good question, and it's not the first time somebody's asked it, so I've actually somewhat looked it up, because the first time I had no idea. So technically, the kids, as long as they're minors, are being overseen by the court. So it would be, again, the judge making a decision on what's in the best interest. Oh wait, because I'm not that loud. I can't compete with that. So again, it's going to be the judges looking at what's in the best interest of the children. So it's not like the guardian who took over would have an estate plan that would then.
So your estate plan is void essentially after the
I don't think
first
it's.
guardians have taken over?
I don't think so. I would have recommended that keep those. Again, it's your voice for after you're gone. So if it's still there, it can be shown to a judge to say these were the other people they picked. This was their second choice. They want to do it. Let's go with that.
Like what, do they, adopt them?
Exactly. So to be able to, for the guardian to have a choice on the next guardian, they would have to adopt the children. Yeah.
Can something like that be in your plan? Like,
You're free to adopt.
Yeah. Is that normally done?
I haven't done it, but I mean they're free to do so. I mean maybe that is something I could add in, but maybe that's part of the conversation that you have with the guardian ahead of time.
So I guess, what's the difference between just being passed on to the guardian and then the guardian doing an adoption? What's the significance of that?
So I believe adopting them gives them those greater rights, essentially more of being a parent, whereas just the legal guardian is a guardian who is looking after them. It doesn't have the same rights as a parent, a full parent. Question back.
Along those same lines, if they adopted the children later on, the assets that are in the trust for the kids are still theirs, not the new parents.
Right. Yeah. So the children are named as beneficiaries, and that won't change as if they have adoptive parents. Although then they might have an inheritance from them as well. So, but they wouldn't. The adopted parents wouldn't have a claim towards the assets in the trust.
It seems like it's not uncommon to have a lawyer be the trustee when it comes to the finance. That's what I've seen. As opposed to like another relative. Be the most potentially comprised.
Yeah. I mean, I don't because it's for us, it's a whole different industry almost. Like we couldn't get insurance, or we'd have a whole different insurance thing if we were acting as trustee. There are companies that serve as trustee, like outside of a bank, that's just what they do. They manage the assets and handle that. I usually am named as an option for a trust protector, which is like a watchdog position, and that's somebody who would come in if the trustee is acting inappropriately or there's complaints from the beneficiary. The trust protector can come in and replace the trustee, just kind of help fix things up. But yeah, typically, I tell people it's somebody who's going to be managing the assets should be somebody you trust, is honest and organized, right? And can keep track of bills and expenses and spreadsheets.
If you have kids that potentially won't be able to sit alongside the topic, that will have some sort of, again, a trust to help them live and pay for their needs.
Yeah.
That would have to be also I'm assuming that would be in the will or in the will. So if you were gone from the guardians to go to something similar.
Yeah. And that's why I mentioned that, not all trusts are the same. So like a bare bones trust you might get online I've seen some that are 4 pages long. The ones that I make are like 70 pages long because there's so many different variables built in. And one of them, the most common is that if there's a special needs beneficiary, essentially a new trust will be created that will stay with that child for their lifetime, so that the assets within that special needs trust are always managed, and they're also not counted against them for government benefits like Social Security, income, disability, that type of thing. Right, because if they inherit something outright, or if it's not labeled properly, then they get disqualified from a lot of those government support until they have less than $3,000. That goes back to my days doing disability work. That was a lot of the claims were young adults who became once they hit 18, then they needed to qualify for benefits, and if they had some sort of money, then they basically had to spend it all and get rid of it before they could qualify for the programs. So the special needs trust within your living trust can prevent them from having to spend down all of their assets. How are we doing? Is it a lot? Is it too much to take in? Deep thoughts? No?
Makes me want to buy more life insurance.
Yeah, and actually the last presentation, people were asking about insurance, and I asked an advisor since then, and he sent back a thing today, and I did not bring it with me, but I will send it in the follow-up. But his general advice was, to think about what your hopes, dreams, and goals are for your children, and to think about what it would take financially to achieve those. And if you're not around anymore to provide that, if you're from income, from working or whatever, to figure out how much would be needed to, send them to college, things like that. And typically, he said, if you have plans like that, then whatever your employer offers is not going to cover that. Usually it's like 1.5, maybe 2 times salary. So that'll get people through the initial year or so. But
imagine if something happens to you, whatever the money in your 401k, is that paid out without tax dollars if you pass away? Say you set up a trust and it goes through there, is there a tax? You said the estate tax would only come into play if it's over like, what did you say it was like?
2.1. And so that's another thing that could be built into a living trust is what to do with retirement accounts. So if somebody is to inherit a pre-tax retirement account, they can continue to have that pre-tax benefit, essentially have it stretched out over their lifetime versus just getting a check. Say, here's the check, and they spend it, and then they get the income tax on it. Right? So there's a way to say, if you inherit an IRA, to say, I'm just going to take, whatever is required, a small amount, and then leave it in the account to continue to grow and avoid paying those taxes.
Is that 2.1? So if something happened to both of us, right, that would be
per person.
Over that 2.1 million, then we would have to have something like that. It's not per person? Or?
So it's 2.1 per person. So if you died at the same time, it would be about 4.2. It goes up every year with inflation. But that's just for an estate tax. There's also capital gains taxes, and usually income taxes is the big one people are worried about. If you died with $500K in a pre-tax account, and whoever has your account calls the beneficiary and says, what do I do with the money? And they just send a check somewhere. If that person just takes it and spends it, they've bumped themselves up into the 37% tax bracket. Most people spend inheritance that they get within a few months, but the tax bill doesn't come till the next year. So suddenly they have like a $40,000, $50,000 tax bill, and So, but hopefully your whoever you have your money with won't just do that. But that's kind of the worst case scenario. So much to plan for, yeah. But the first thing you could do that's really easy is getting the guardians done. You can break these down into steps. We used to bring forms for the guardian things, but I don't know. I was always worried that people would go and do them wrong or not do them. I don't know. That website is really good though, because it walks you through the process and has instructions for everything. And if you're really worried about it, I'm happy to take a quick look at them and tell you if you did it right or wrong. So. All right. Anyone else?
Thank you for
taking
the time.
Yeah. You're welcome.
Where are you located?
South Lake Union.
For money, anyway. You get unplanned property. Just $1 will be put in the
You're welcome.